Good morning, back to you on this day, August 23rd, 2020, because my last video which I prepared just now was broken because of signal register intervened. So I am giving this now issue of contract to you on share, screen share. Screen share, if I start a screen share means it's difficult to contact back on talk. So I'm just giving you this 1 hour presentation to you for for silver contract standard, that is EPC turnkey project, which is very important for engineers. It's very important for engineers because this type of contracts are very important for whatever nation's economy, national economy. Such type of projects are very significant. If such projects do not happen, such arrangements don't happen, we cannot develop our nations, because these EPCs are generally used for high value projects where you can say designs etc. are included in project itself. In that contract itself means there is no you can say that there is no, these are included a part of contract, and this contract which says that you are responsible for complete package of scope of work, that is say including conception, including designs, and before designs including feed also. If it's that FEED, we usually call it feed, stands for front end engineering design, and that's very important for designers to follow criteria set for that project. It's pre-designed arrangements, and it says, it tells designer, it guides designer, it instructs designer, it directs designer what procedure, what management, what formula, what theories to be included while conducting detailed designs. That's called FEED, FEED, front end engineering design. Front end engineering design. That's very important part, and it may include EPC, or it may supplement EPC. It depends upon employer and policy of employing organization. Employing organization, I say, it's something actually, if you consider facilities projects means those projects which are meant for high level national economy. You may say, for example, where oil onshore or offshore projects are involved. I'm talking of that. That one may be here, may be there, but it should be somewhere. That can be, and that is, that's where we can say it's valid or not valid. That point is important here. That point is very important for economy and for everything. Economy doesn't move in its own, it moves on industrialization of whatever nation. And industrialization means mega projects. For example, some organization whom we called employer now in contract, but that's actually company, not a contracting company, but a company that promotes, say, natural resources, extraction of petrochemical products from sea or onshore as well as offshore. Let's talk of onshore, because onshore is meant for refining those raw materials which we get from offshore. Even from offshore we get these materials. Offshore itself is a different domain, which is also, you can say, a super national economy generator. EPC, it's not easy to say that this is engineering, procurement and construction only. That's only term given to it. But behind scene, a lot exists. That point we must understand. This document which I am showing you, this is not end. End is with you. This document is a supplement and it's called 2017 Silver Book, which is meant for turnkey projects or EPC project. I talked about this before also. Once we consider red book and the silver book, these are reference books which can be used for purpose of contracting. And because red book is meant for those projects where designs are provided by employer through engineer and contractor is required to do scope of work in which complete execution or complete prosecution, or can say complete carrying out of those scope of work included in those except design. I mean to say except prime design, not secondary designs. Secondary designs are included in scope of contracting organization. Under such contracts, which may be shop drawings designs, working drawings designs, or some other minor designs, just we conduct for sake of running project. So where designs, structural designs, architectural designs, schematic services designs and specifications well drawn, and all are provided by engineer for employers. That is called red book. Now we are talking about silver book, which is EPC, and this means this is complete responsibility of contracting organization and not of employer. Employer is a promoter or whosoever has to invest money in that project and pay to contracting organization whenever required. It's organization itself, and contractor are very powerful organizations. We cannot say that they are shop-like. They are full-fledged organized groups, and they are called companies in such language. Means these companies are high economic companies which deliver to public, such for example oil company, or you may say very big companies like in any other field, and these impact economy directly and these play billions. But it is not essential that only such EPC are valid for them. These can be valid for some other projects also. For example, building construction, building promotion, or development works, or some other flyover or bridges, or means it can be applied anywhere, but prime application is there. Yet this can be applied here. For means design can be done by engineers, structural designs for all these infrastructural components like buildings, like bridges, like flyovers, and likewise these refineries, or like you can these facilities, plants, like whatsoever you can say, this can be designed. And not only this design in structural aspects, but also in mechanized aspect, in mechanical aspect, the machine or vessels aspect, in electrical aspects, in cathodic production aspect, in aspects of other services, in aspects of process plants, in aspects of piping work, in aspects of, you can say, services whatsoever required, and also pulling out sea water for cooling purpose, and also for collecting those waters in some lagoon areas, and also for disposing back that water to sea. So many activities, prime activities are involved. There's no limit. It can be done. Means product is processed and delivered, and not necessary. It means it's a direct product from, see, also bioproducts which received from refineries are processed to or SADA, for example. This can be ethylene project, you can say polyethylene project, and many others alkali projects. Likewise, there are so many. So we just have to understand about technology of those projects as well as contracting structure of those projects. Technology is one part. Without understanding and taking complete grip of that technology, we cannot understand how contracts impact and apply onto them. It's very big understanding required for this EPC. EPC means when design is yours and procurement is yours, and every part of contract and project yours except land, you have to be very responsible person. Very responsible in our respects means it's not single person job. It's job of complete team of that organization, and then further detailed team of those contractors who get job from that's called EPC contractor. That must have further extended organization but subsidiary to that main organization of company, and then further organizations, sub-organizations, you can say, from those specialist subcontractors who would work on those projects, and also those organizations which are used for procurement of equipment, procurement of machines, and procurement of all those elements or components required in such projects. And that's why it's completely many multilateral project, you can say. This contract itself is multilateral, multi-tier. You cannot simply say in one line, do it and go. It takes lot of time, very detailed time, revisions of designs, rejections of designs, and rejections of equipment delivered by mistake, and like that, because future lies in risk. Always there is risk of which failure of plant, environment explosion. Maybe there may be vapor formation within area of circulation of that plant. There can be gas formation, fires, explosion risk are very important, and that's why some blast buildings are also constructed in those areas which cover particularly specific scope of processing plants area. So there are so many areas in such plants. You can say top area is processing plant, then there may be utilities passing through all areas. There may be off sites, there may be administration area, there may be warehousing area, there may be central control areas and infrastructure areas within, and many electrical substations, and so much you can see on any plant. If you go and you see, you will find that it's very significant. So contract must be done accordingly. It's not ordinary contract, but based on long-term impact on those kinds, very important. That's what I say. So what I'm saying is, I'm not scaring someone, but contract structured for such projects, contract language for such projects should be accordingly in alliance with requirement, say in conjunction with requirement, what requirement is about, because these contracts are not for 1 month or 2 months. These contracts can move for years together, we say 3 years and 4 years, and then maintenance period itself, and design period, and then pre-design period. All those required to be covered in that. And design is not structural design alone. Design is architectural design for buildings, and then you can say structural designs, and then machine and equipment designs, and then you have to see all designs fit in requirement of process, and that's why it takes time, and there will be many items and many requirements on such projects. Multidisciplinary projects, you can say. It's not single discipline projects. Majority of equipments and vessels and high status of structural engineering work or civil engineering works, and various buildings. So you can say there are many disciplines, many specialist disciplines required for such project. That point we must clearly understand in this kind of projects. You cannot take them for granted. So is contract required, and one must have vast knowledge to understand such projects. If some director or project manager or project engineer for such project means should be fittest one, not that I just. It's high level of experience and knowledge required. So that's the EPC contract is like that. Means it's the contractor as well as his employer must be smart enough to deal with such contract. You should have experience of all disciplines, and you must have many managers or coordinators for this technical, contractual, and site alliance or site coordination, and that's very important. In absence of such coordination, you can say projects then do not mean anything. These projects do not mean anything otherwise. So I was discussing this one. I went a lot of that one. I am showing this file. You can see contents of this file. I am just starting contents of this file, and it goes on and on and on. And technicalities are not valued. People don't understand technicalities of such projects, but that's very important point. Technical understanding of such projects, and then you can say you have to move on these projects to understandable contracts. And I also clear that 90% engineers do not take interest in such contracts or other contracts as well. As you can say, it is red book. It's very it's really astonishing that we don't understand impacts of contract, and we keep ourselves, we find ourselves in some kind of you can say a kind of situation where no identity means this contract setup should be in our mind. Red book it may be, or silver book it may be, or white book it may be, or yellow book it may be. All these we will study gradually from viewpoint of practice, not viewpoint of theory. I'm not interested in talking clauses in details of theory, but link to those clauses on practice of contracting and consultancy as well as employers. We want to understand basics of that. It's not a question of examination. We have examined and we have to answer questions. No, that's not requirement here. Requirement here is something different. Requirement here we have to be clear about that. Clear and completely clear. Because these contracts and technical work, just like this is a technical, I can say this is a technical here. Another file that's technical. I used to discuss it also. This is some report, it means soil investigation report. These reports and such kind of projects are very much related to each other. You can say this report which I am showing to you, just I'm just browsing it for you, showing that there are such reports. This is actually soil report, which I was discussing this as well as soil reports and such projects, which I say such projects are very much linked together because progress of such projects, success of such work depends on engineering, depends on engineering, total engineering, and soil engineering is one of that. And soil engineering is beginning of project. It may be beginning as well as, because without soil engineering we cannot understand even logic or justification where the project lies in. So in this FIDIC we have about just like in other one track book, there are 20 plus 1 clauses. In this also 21 clauses. So I am saying, asking 20 plus 1, I am saying yes, 21 clause is actually arbitration disputes resolution mechanism, which is not integrated part of such contracts. That's a separate part, can say. Now, with this point, I'm just trying to explain to you what I'm talking on, and as much as I can, because I'm very serious as far as contracts are concerned. I'm a very serious person. I have done some work on this in depth, and I want to understand. I've seen some difficulties also in life regarding contracts, and I understand that engineers generally often they do not take interest in such requirements, which are of course very important, but by chance, due to some reason, whatever reason is, I don't know, they don't take interest in that, and they suffer, of course, which they should not, but unfortunately it happens. So this is general provision in this, and I'm just repeating for references to those maybe who have not gone through this before. General provisions in this clause number 1, and this gives definition, interpretation, notices, and other communications, law and language, priority of documents, contract agreement, assignments, care and supply of documents, employers' use of contracts use of employers' documents confidentially, compliance with laws, joint and several liability, limitation of liability, contract termination, and you see clause number 2, employers' right of access to site, existence, employers' personal and other contracts, employers' financial arrangements, site data and time to reference, employers' supplied material and employers' equipment. Number 3 is employers' administration, employees' representative, others employees' personal, delegated persons, instructions, agreement determinations and meetings, and contract number 4 is contractors' general obligations, performance security, contractors' representatives of contractors, normal nominated subcontractors' cooperation, setting out health and safety obligations, quality management and compliance verification system, use of site data, sufficiency of contract price, unforeseeable difficulties, right of way and facilities, avoidance of interference, access routes, and transport of goods, contractors' equipment, production of environment, temporary utilities, progress report, security of sites, contractors' operations on site, archaeological and geological findings. And then design. Number 5, general design obligations, contractors' documents, contracts and undertaking, technical standards and regulations, training as built records, operation and maintenance manuals, design errors in staff and labor. 5 and 6, engagement of staff and laborers, rates of wage and conditions of labor, recruitment of persons, labor laws, working hours, facilities for staff and labor, health and safety personnel, contract superintendents, personal and contracts records, and disorderly conduct, key personnel, plant maintenance and workmanship, manner of execution, samples, inspections, testing by contractor, defects and rejection, remedial works, and ownership of plant and materials and royalties. And then number 8 is commencement delays and suspensions. Actually, I had to discuss this. Commencement of works, time for completion, program, advance warning, extension of time for completion, and delays caused by authorities, rate of progress, delay damages, employer suspension, consequences of employer's suspension, and payment for plant and materials after employer suspension, and prolonged suspension, prolonged supervision, resumption of work, tests on completion. Number 9, that is, contractors' obligations, delayed tests and retesting, failure to pass test on completion, employers taking over. Employers taking over means, you can say, employers taking over means taking over the works and taking over works and sections, and taking over parts of works, and interference with tests on completion. Defects after taking over, and that's another one, is completion of outstanding work and remedying defects, remedying defects, cost of remedying defects, extension of defects, notification period, and notification period, failure to remedy defects, and fail to remedy, remedying of defective work site, further tests after remedying defects, right of access after taking over, contractor to search, performance certificate, unfulfilled obligations, clearance of site, and tests after completion of 12, procedure of tests after completion, delayed test and ref testing and retesting and failure to pass test after completion, variations and adjustments. Number 13, right to vary, value engineering, variation procedure, provisional sums and day work, application of changes in laws, administration, adjustments for changes in costs. And 14, contract price and payment. Contract price, advance payment, application for interim payment, schedule of payments, plants and materials intended for works. And then interim payments, delayed payments, release of retention money, statement and completion, final statement, discharge, final payment, cessation of employer's liability, currencies at payment of payment. That it is termination by employer is number 15. Notice to connect, termination for contractor's default, valuation after termination for contractor's default, payment after termination by contractor's default, termination for employer's convenience, and then variation and termination for employers. Then you can say valuation after and then payment after termination of employer's convenience, suspension after termination of employer, clause 16, suspension by contractor, termination by contractor, contract's obligations after termination, payment after termination of contractor, number 17 care of works and indemnities, and that is responsibility for care of works, liability for care of works, intellectual and industrial property rights and administration and indemnities by contractor, indemnities by employer, share indemnities. Then you see exceptional events and exceptional events, notice of an exceptional event, derive duty to minimize delay, consequences of exceptional events, optional termination, release from performance. And this clause, exceptional events, is a modification of force majeure. Actually, there was force majeure before, now they have removed that one, and that's the exceptional events they have taken. So maybe some people could not understand meaning of force majeure. I'm not talking of this country, maybe other than our country, British, the rest of country could not understand maybe force majeure. So yeah, they are just brought in direct, just like right to be police. Yeah, that's not case. It means that exceptional events is the same thing as force majeure, and more justification available, not just an imaginary world whether you have to do jurisdiction or jurisdiction that. And that's the insurance, that's general requirements, insurance, the proper provided by contractor, the employers and contracts claim. That's number 20. Yeah, until here can say it's a part of contract. And this is disputes and arbitration. That's another word. It's also more specific than. And then all claims are raised here, and that document should be having all claims, whatever claims you have. And then the appendix and indexes of clauses, etc., etc. Now, there are so many terms and definitions in these clauses, and I'm just browsing for you people so that you know what is there. I'm not going to speak again for all. I've already done that. Just I'm browsing for your purpose, means what contracts and subcontracts are there, and what we should do, what we should do. Now you can see I'm going to that part of where we have to see how to handle something which is very unique in a sense. Rarely happens, but can happen. You cannot say with guarantee this does not happen or this shall not happen, but that can happen. It can happen, and it happened also in various places. Now, my interest is to share with you people about various, you know, procedures that are required on contracts, which are actually which are understood based on experience and not exclusively from theoretical knowledge or industry. That point is very important on contracts because if you know the spirit of job, so I move on to suspension. I mean to say, just sorry. Actually, this is very important document. Though it's not mandatory you follow this, but you have to understand this. Because even if you don't follow this, if contractors are there, EPC contractor, their contract what it says, you have to understand that. And if you don't understand that one, you means as an engineer, you shall certainly find a problem. That problem should be avoided. Plant materials sector we are done. Oh, yeah, that's how we see commencement delays and suspension, which is very contractual and technical issue. It's very much administrative issue as well. All these issues, commencement delays and suspensions, as I talked also in past that there are many parts on contract. One part is contractual one part is technical one part is quality one, and one part is accounting of contract, billing or valuation, and contract relations. Contractual relation that form among all those stakeholders and primary stakeholders like which are employer and contracting organization. They are primarily responsible for project, and without them commencement delays and suspension actually are root of all problems. Suspension is rare, but you cannot say it doesn't happen. Delays are common. And commencement is very fast, but its continuation is a problem. Again I say, contracts means high responsibility, because if contract fails, everything fails. A delay of a single day costs a lot. It costs contracting party damage, and it costs employer delay on commissioning, delay on start of project, delay on production. These cannot be taken for granted because these amount to millions and millions and trillions, billions, what it is. This is something extraordinary. And because our engineers in Bharat, India, Except few, you can say, except few scholar type engineers or very, very senior position engineers. They may be knowing, they may know, I'm certain they know about contracts. But there is no culture here that it should be common for engineers. I have worked with British, I have worked with many others. They keep on referring all time to contract. Whatever they do, either from consultant and or from contractor and or from employer end, there are some parts, some basis you may say, that they set those questions. Setting of questions is not enough. Setting of solution, resolving it enough. As for example, you say commencement works here, there's time of completion, then program is there, then you may say there is advance warning and extension of time for completion. There are delays caused by authorities. Delays caused by authorities. Rising of. Rate of progress and delay damages, then employer suspension, and payment for plant and machinery after employer suspension, prolonged suspension, resumption of works. So resumption of work, etc. These are very important clauses, but these are not all clauses. As far as these clauses are concerned, no one can take this, remember. But also simultaneously, we cannot put ourselves in danger or trouble of being gripped in future on contract. If commencement is good, it doesn't mean everything is good. In interest of project, every party tries to rapidly move in beginning. But they are short race oriented people. If they are not prepared for continuation on a smooth track, if I am not prepared for whole journey, why should I start journey? Maybe I say just to show, we start reach some kilometer and then we take rest. If there is such state that you are not ready, with whatever means source, you are not ready with resources, you are not ready with equipments, or you are not ready, and you keep on saying, okay, we take time now, we will not work for, we work very slackly for 2-3 months after we push up. That point could be very reviewed. At that time your mind is only 40%. Question is delay. Delay is very dangerous on contracts. Delay for whatever reason. Somebody says there is a delay, how shall we recover this lost time? I argue every time. First tell me why there is delay. because we are not here in school or university. We should understand what is the way. Even a single hour delay is important. Single hour. Because when we plan something, we schedule out something, we do not take margins, particularly on industrial projects. When there is so much quantity of concrete, so many foundations, so many buildings, and all infrastructure facilities, we are going to be required. You can walk in. Delay has to be avoided convertibly. Employer also is required to think in this matter. It's not simply saying I signed contract, I given the contract responsibility of contract to take care of this. That's okay. That's contextual part. But intentional part I'm talking, intentional part. contract once gripped by engineers, by contractors, do find success in timely delivery, in quality, in safety, and latest in testing and commissioning. It's wide spectrum. It's not simply saying that this is construction, this is liability contract, responsibility contract, cost contract, and this is high profile contract where high profile people are required in commencement, in progress running, in designs, working designs, and in all disciplines. Many factors are required. Heavy equipments are procured, heavy machines are procured, and you can say so much is done in this. And then construction, of course, foundations, structures, buildings, infrastructure, roads, utilities, and so much that elements are many and it takes time. So we should be realistic in such contracts that you should not squeeze even required duration, even that duration, even if you have 12 hours a day, and if that duration you think it should be more than that, and you can get infinite results. It doesn't happen like this. Here, work is more important than lockdown. Work is important than lockdown, and lockdown doesn't work here. In term these days we say lockdown on contracts. If you do, then there is no benefit, only losses and losses and losses. So we say commencement of works means unless commencement date is stated in contract agreement, employer shall give a notice to contractor stating commencement date for not less than 14 days before commencement date. 14 days, because each day is important, so we cannot deny this fact. Everything is important. Now, unless otherwise stated in particular conditions, commencement date shall be within 42 days, or commencement date shall be 42 days after date on which contract comes into full force and effect under such clause. So let us read again. Unless commencement date is stated in contract agreement, employer shall give a notice to contractor stating commencement date not less than 14 days before commencement day. This means there should be a margin of 14 days. Warning, you can say 14 days. A kind of notice that you have to start in 14 days and you must start your project in an executive model. Then, unless otherwise stated in particular conditions, commencement date shall be within 42 days after date on which the government comes into contract. Then you can say contractor shall commence execution of works on or as soon as is reasonably practicable after commencement date, and shall then proceed with works with due expeditions and without delay. Then time of completion, as it says that contractor shall complete whole works and each section, if whatever, within time of completion for works or section, as case may be, including completion of all works which is stated in contract as being required for works on section to be considered, to be completed for purposes of taking over under subclause 10.1, taking over works and sections. Program 8.3. Contract shall submit an initial program for execution of works to employer within you can say 28 days after receiving notice period, notice under subclause 8.1, this program shall be prepared using programming software stated in employer's requirements if not stated. Programming software acceptable to employer. Unless otherwise stated in particular conditions, contractor shall also submit a revised program which accurately reflects actual progress of works. Whenever some program ceases to reflect actual progress or is otherwise inconsistent with contractor's obligations. Now, initial program and each revised program should be submitted to employer. Initial program and each revised program shall be submitted to employer in one paper copy, one electronic copy, and additional paper copies as stated in contract data and shall include. What shall include? That's the point here. These are the important points given here. Let's say A, commencement date and time for completion of works and of each section. And other one is B, that is date, right of access and to right of access and to position of each part of site. That's date. The proposed site is to be given to contractor in accordance with subclause 2.1, right of access to site. And C, order in which contractor intends to carry out works, including anticipated timing of each stage of the site. Preparation and submission of contractor's documents, procurement, manufacture, and we and you can say in this, you may say that in order which contractor intends to carry out works, including anticipated timing of each stage of design, preparation and submission of contractor's documents, procurement, manufacture, inspection, delivery to site, construction, erection, installation, work to be undertaken by whatever nominated subcontractor as defined in clause 4.5, nominated subcontractors, testing, commissioning and trial operations. I read this paragraph because this paragraph tells you something specially. It says, order in which contractor intends to carry out works. That's more important, because contractors keep in view site layout and will keep, because such works are not very small or big and many facilities are required. Their temporary facilities, preparatory facilities and permanent facilities are required, and they have to manage all resources, site manufacturing and whatever is required in that. Very careful studies will be conducted. Therefore, preparation and submission of contractors' documents, procurement, manufacture, inspections, Then you can say that preparation and submission of contracts is document. Design is big part. Anticipated timings of each stage of design. Many stages are here. Then preparation and submission of contractors document is design and then approvals of them, and then procurement of them, and the manufacture of them, and inspection of them, and the delivery to site, and then construction, then erection, then installation. What means one part is design part and procurement part, and one part of construction part. So here are one part of order part, that's one part. Then you can say design, preparation and procurement part, and also then you can say construction, erection, installation part, and these works to be undertaken by certain nominated subcontractors could be as defined in class 4.5 nominated subcontractors. Testing and commissioning the other part, and trial operation. See, one paragraph has consumed as contained in this complete working activities of project, which is analyzable. You should analyze yourself, and we'll analyze that. Indeed, we'll do that. And to D, that's review periods under subclass 522, review by employer, and periods for review for whatever other submissions specified in employer's requirements are required under these conditions. E, sequence and timing of inspections and tests specified in or required by contract. Specified in or required by contract. These are two different terms. And F says for a revised program, sequence and timings of remedial work, if whatever to which employer has given a notice of no objection under subclause 7.5, defects and rejection, and or remedial work, if whatever instructed under subclause 7.6, remedial works. All activities to level of detail specified in employer's requirements, and you can say logically linked, also, I think you say logically linked with that, and logically linked, and showing earliest and latest start and finish date for each activity. Float whatever if and critical paths, and then it is H, you can say dates of all locally, you can say locally recognized days of rest and holiday periods, if whatever, if any, and well, these are here means then all keys, deliveries, dates of plants and materials, and J for revised program and for activity, actual progress to date, and whatever delay to such progress and effects of such delay on other activities. And next is K, supporting report, which includes 1. Description of all major stages of execution of works. General description of methods which contractor intends to adopt in execution of works. That's most important here. General description of methods which contractor intends to adopt in execution of works. Details showing contractors' reasonable estimate of number of each class of contractor's personnel and of each type of contractor's equipment required on site for Each major stage of execution of works. And then if a revised program, identification of whatever significant changes to previous program submitted by contractor, then contractors proposals to overcome effects of whatever delays on progress of works. Employer shall review Employer shall review initial program and each revised program submitted by contractor and may give a notice to contractor stating extent to which it does not comply with contract or ceases to reflect actual progress or is otherwise inconsistent with contractor's obligations. If employer gives no such notice within 21 days after receiving initial program or within 14 days after receiving a revised program, employers shall be deemed to have given a notice of no objection and initial program or revised program, as case may be, shall be program. Contractor shall proceed in accordance with program subject to contractor's other obligations under contract. Employers' personnel shall be entitled to rely on program when planning to their activities. Nothing in any program or any support or supporting report shall be taken as or relieve contractor from whatever obligation to give in notice under contract. If at any time, whatever time employer gives in notice to contractor that program fails to extend stated to comply with contract or ceases to reflect actual progress or is otherwise inconsistent with contractor's obligations, contractor shall within 14 days after receiving this notice submit revised program, employer in accordance with this subclause. Then advance warning. Each party shall advise other party in advance of whatever known or probable future events of circumstances which may adversely affect works of contractor's personnel, adversely affect performance of works when completed, increase contract price and or delay execution of works or a section, whatever. Employer may request contractor to submit a proposal under subclause 13.3.2, variation by request for proposal to avoid minimize effect of such even circumstances. An extension for completion. Contractors shall be entitled, subject to subclause 20.2 claims for payment under or EOT extension of time if and to extent that completion for purposes of subclause 10.1 taking over works and sections is well or will be delayed by whatever following causes, and that is a variation except that there shall be no requirement to comply with subclause 20.2 claims for payment and or EOT. B. Clause of delay giving an entitlement to EOT under a subclause of these conditions or whatever delay, impediment or prevention caused by attributes to employer for employer's personnel or employer's other contractors on site for whatever unreasonable shortage in availability of employer supplied materials. and whatever is caused by epidemic or governmental actions. When, when determining each EOT under each extension of time under subclause 20.2, claims for payment and EOT, employer's representative shall reveal previous determinations under subclause 3.5 agreement or determination and may increase but shall not decrease total EOT. If a day caused by a matter which is employer's responsibility is concurrent with a delay caused by matter which is contractor's responsibility, contractor entitlement to EOT shall be assessed in accordance with rules and procedures stated in special provisions, if not stated as appropriate, taking due regard of all relevant circumstances. Then we can say delays caused by authorities, which is if contractor has diligently followed procedures laid down by relevant legally constituted public authorities or private utility entities in country, those authorities or entities delay or disrupt contractor's work and delay or disruption was unforeseeable, and this delay or disruption shall be considered as a cause of delay under subparagraph B of subclause 8.5, extension of time for completion and rate of progress. Rate of progress. Rate of progress, and that is, if whatever time actual progress is too slow to complete works or a section, if whatever within relevant time for completion and our progress has fallen behind program or initial program, it does not yet become program under subclause 8.3 program, other than as a result of cause listed in subclause 8.5 EOT extension of time, then employer may instruct contractor to submit under subclause 8.3 program a revised program describing revised methods which contractor proposes to adopt in order to expedite progress and complete works or a section, whatever, even within relevant time for completion. Unless employer gives notice to contractor stating otherwise, contractor shall adopt these revised methods which may require increase in working hours or number of contractors' personnel and all goods at contract's risk and cost. These revised methods cause employer to incur additional costs. Employer shall be entitled subject to subclause 20.2 claims of payment and EOT payment to these caused by contractor in relation. Subclause 13.1 variation by instruction. Instruction shall apply to revised methods, including acceleration measures, instructed by employer to reduce delays resulting from cause listed. Subclause 13.3.1 variation by instruction shall apply to revised methods, including acceleration measures instructed by employer to reduce delays to reduce delays resulting from causes listed under subclause 8.5, extension of time for completion. Delay damages, that is, if contractor fails to comply with subclause 8.2 time for completion, employer shall be entitled, subject to subclause 2010, claims for payment and or extension of time to payment of delay damages by contractor for this default. Delay damages shall be amount stated in contract item, which shall be paid for every day which elapsed between relevant time for completion and relevant date of completion of works or section. A total amount due under subclause shall not exceed maximum amount of delay damages if whatever stated in contracts. These delay damages shall be only damages due from contractor for contractor's failure to comply with subclause 8.2. Time for completion other than event of termination or under subclause 15.2 termination of our contract's default before completion of then you can say this subclause shall not limit contract's liability for delay damages in whatever case of fraud, gross negligence, deliberate default or reckless misconduct by contractor. Employer suspension, that is, employer may at whatever time instruct contractor to suspend progress of part or all of works, which instruction shall state date and cause of suspension. During such suspension, contractor shall protect, store and secure such part or all of works as case may be against whatever deterioration, loss or damage. To extend that cause of suspension is responsibility of contractor, subclause 8.10. Consequence of employer's suspension, payment for plant and materials after employer's suspension, and the prolonged suspension shall not apply. Consequence of employer's suspension. Now, if contractor suffers delay and or incurs cost from complying with an employer's instruction under subclause 8.9, employer suspension, and or from resuming work under subclause 8.13, resumption of work, contract shall be entitled, subject to subclause 20.2, claims for payment under EOT or EOT and or payment of such costs plus profit. Contractor shall not be entitled to EOT or to payment of costs incurred in making good. Consequences of contractor's faulty or defective design, workmanship, part or material and or whatever deterioration, loss or damage caused by contractor's failure to protect, store or secure in accordance with subclause 8.9 employer's suspension. 8.11 payment for plant and materials after employer suspension. So suspension still is very long, I think. Payment to plant and materials, after employer suspension. Contractor shall be entitled to payment of value as to date as of suspension instructed under subclause 8.9, employer suspension of plant and of materials which have not been delivered to site if a work on plant or delivery of plant and of material has been suspended for more than 28 days and 1. In plant or materials for scheduled in accordance with program to have been completed and ready for delivery to site during suspension period, and contractor provides employer with reasonable evidence that plant and material comply with contract and the contractor has marked plant and materials as employer's property in accordance with employer's instructions. Prolonged suspension. Prolonged. If suspension under subclause 8.9 employer suspension has continued for more than 84 days, or you can say 12 weeks, contractor may give a notice to employer requesting permission to proceed. If employer does not give a notice under subclause 8.13, resumption work within 28 days after receiving contractor's notice under this subclause, contractor may either A, agree to a further suspension, in which case parties may agree EOT and or cost plus profit. If contractor incurs cost and or payment for suspended part or materials arising from total period of suspension, and if parties fail to reach agreement under subgraph. After giving a second notice to employer, treat suspension as an omission of affected part of works as if it had been instructed under subclause 13.3.1, variation by instruction with immediate effect, including after giving notice to employer, treat suspension as an omission of affected part of work as if it had been instructed under subclause 13.3.1, variation by instruction with immediate effect, including release from any further obligation to protect, store and secure under subclause 8.9 employer suspension if suspension affects whole work. Contractor may give a notice of termination on subclause 16.2, termination by contractor, and resumption of work. Contractor shall resume work as soon as practicable after receiving a notice from employer to proceed with suspended work. Same stated in this contract. If not stated, immediately after contractor receives a notice, contractor and employer shall jointly examine works and plans and materials affected by suspension. Employer shall record deterioration, loss, damage or defects in works or plant or materials which has occurred during suspension and shall provide this record to contractor. Contractor shall promptly make good all such deterioration, bleeding, loss, damage or defects so that works when completed shall comply with contract. This part that we discussed here is, we can also see this file, other file that is, more technical test we discussed yesterday, before yesterday something. I could not do it, but this is also very important at the same time because this relates to such kind of projects. This file which I am showing you is having, about you can say 28 bore logs and many target, test bits and electrical resistivity tests, and you can say thermal resistivity tests and many more kinds of tests it has conducted. And this is very important file for purpose of study. And I raised this file in last this file cannot be skipped. This file is very important from every point of view, and we must have our value for that. And there are so many files as such, like you can say there was a SPT standard penetration test also. Then there was many other tests, pages I shared with you last time, and these are very important one. This one cannot say that these are general files I am telling you. Also with this, if I bring to attention, you can say another file, let us say this file that is, this file is other one, and it says there's another file which is, it's giving also part of test, giving moisture density, etc. here, which is also very important one. And you can say it's important file. This is saying from point of view of understanding technology, how it's conducted in size. I just move on this to show you what actually is this all about. It's just you can say a glimpse of this. I'm showing you so many results of same, and also so many results like others, and same results there. Like this, you can say, you can move on to these files. And now contract itself, is strategically very important for engineers, because contract means project, and if there's no contract, you cannot do project. That's also true. We have to understand this point very well. So I don't have much time now. I would like to close it. It's already, I think, about what to do. There is no more time for this. We have to understand. I just tried to communicate to you about the silver. Before this, I have to do another video regarding soil So basic properties, and also this is a mix of document sharing. And I have noticed that same pattern of files can be shared one after other. If, for example, it is PDF, can be shared PDF. If it's Word, we can continue Word files. So this is the method here. I could understand. We have to take into our considerations all these points are very important, and we should think of how to proceed in future. I shall like to do separately. I shall like to do separately certain structural theory of structural, theory of structural formula which I used in my designs. This formula involving Carney's relation diffusion method. I want to share that also with you. Means how compositions of those designs was used. It's not done now. This is done, you can say, long back. It's that time. Maybe. That's what means. Profession of engineering is very much, you can say, very much in fact challenging in a way. We treat it technically, or we treat it contractually, or we treat that, in a way you think so can be treated with, or we may take, yeah, like this I can show you, various others, it in a way you may say that mm, let us say other one, uh, in a way that you can see this another report of soil which is for another project in another country. It's also having certain structure of how to do it with that. This is for some LNG project. Also very important report, not that descriptive yet important. The cell also I'd like to share with you. Means sharing is important here. Means we have to share with you like that. As much as you go, you'll find this. So what I say is, I'm going to say we have to be very logical in understanding our profession. It's not simply profession. It's, you can say, a kind of commitment that we make. We make commitment to people. We make commitment to. There are certain photographs you can see, as I showed you before as well. How this is done. You won't be surprised with that. These are field photographs, and how people used to work many years back. This is that, you can say, just like that. I'm showing you for reference only. It's not that I'm discussing with you that, just for reference, so that you have some interest in this if you are really technical manager or technical somewhere. And this is that. And I'm going to close it because it's already 8:15, and I have to post this file on structural forum also, and that's also a point here. I have to post there as well, and so this post there as well. So then I will close this. It's now come out of